We are back. Fortunately, it's for just one assignment. After that, we'll return to our break, and I hope for a very long time. Very well. So now you may bring in the nominee. Yes, kindly administer the oath. Very well. Yes, we administer the oath.
I, Kissi Agyebeng,
solemnly swear that the evidence I shall give before this committee
solemnly swear that the evidence I shall give before this committee
touching the matter in issue shall be the truth, the whole truth, and nothing but the truth. So help me God.
So help me God.
Mr. William Kissi Agyebeng, on behalf of the committee, I congratulate you on your nomination to the very unenviable position of Special Prosecutor, the second since the office was instituted. Now we have your CV, but kindly tell us a little more about yourself.
Thank you, Honorable Chair. Good morning, Honorable members. Honorable Chair, I used to be called William, but I dropped it officially a while ago. So my name just remains Kissi Agyebeng.
Well, I've seen that William is on relevant certificates.
Yes.
And so it's important for our record.
Yes, I designated it on my 78. I started my primary education at Holy Star Academy at Laboni in Accra. And then we moved from La to Teshi. And I was enrolled at the Wajel Barracks School to continue with my primary education. And this is at the military barracks at Teshi Camp. So in 1989, together with a few of my colleagues, we tried our hands at the common entrance examination. And I enrolled at Damfa LA Middle Mixed School because at that time I was a bit too young to write a common entrance. But on the first try, I passed and I gained admission to Accra Academy, where I did my secondary education. 1996. From there, we waited 2 years to enter the university. But in the interim, I did my first national service at the Information Services Department at Nominee Kissi. In 1998, I gained admission to read law at the University of Ghana, where I graduated in 2001 with a Bachelor of Laws LLB degree, first class honors. And then I proceeded to the Ghana School of Law in 2001. I was called to the bar on 3rd October 2003 after having successfully completed the professional law course. And then I returned to the University of Ghana as a teaching assistant in the law of contract and conflict of laws before 2004. I gained admission to read a Master of Laws program in Marine and Environmental Studies at the Schulich School of Law at Dalhousie University in Halifax, Nova Scotia, Canada in 2004. I graduated in 2005, and then I also proceeded to read another Master of Laws program, LLM, at the Cornell Law School in Ithaca, New York, in the United States. I then returned home, and I was appointed a lecturer in 2006 at the University of Ghana, Faculty of Law, now School of Law, where I've been teaching the past 15 years to date. Alongside that, I was also building my private practice. I had a few things at the Center for Public Interest Law, a human rights public interest law firm. I had another stint at the Legal Resources Center, another human rights law firm. And then around about in 2008, 2009, I joined a new law firm that was being formed, Aina and Feli. I was there till 2013. And in 2014, I formed my own law firm with a partner, Cromwell Gray LLP. And I've remained the managing partner till date. I was appointed as the chairman of the Electronic Communications Tribunal in Honorable Chairman, in sum, these are the highlights of Kissi Agyebeng.
Let me ask you before I continue. All this while that you were moving from one chamber to another, forming your own chambers, you are still an employee of the Ghana School of Law, University of Ghana?
Yes, Honorable Chair. This argument was long won in the 60s when our forebears argued successfully that the law court is the laboratory of the lawyer. So the theories we propound in the law classroom should be tested out there for its veracity. So we are allowed to practice and still lecture at the same time.
You mean it's the university policy that a lecturer at the law faculty can also engage in private legal practice? I just want those things for
Yes, Honorable Chair.
Very well. Leader, should have opened up before he started, but you now may take the floor.
Chairman, I should thank you for the opportunity and should join you And Chairman, I'm doing it on purpose. I'll soon be asking him after my opening remarks when he dropped the formal or informal name of William for our record. But Chairman, this is just to warm him to, as you describe it, the unenviable position, high office of special prosecutor. Ghana needs you to nip corruption because it has shattered the dreams of many, contributed to joblessness in our country and to poverty in our country. So welcome. But Chairman, when did you drop the William? So now Kissi Agyebeng, why did you have to drop William? Even though
Honorable Chair, I've just explained that it had become redundant.
What made it redundant? Was that a baptism name?
It was a baptism
You know you
name.
didn't name yourself. You know that culturally
no,
and religiously.
Actually, Honorable Chair, I would have dropped it. I made my peace with him that I needed to check that foreign name from my name and keep my local names.
All right. So, Chairman, just to, I'm happy you stated that you used to teach conflict of the laws and law of contract. Now, you know the evidential rule, burden of proof, particularly in criminal jurisprudence, proof beyond reasonable doubt. Do you share the view that we should criminalize unexplained wealth in Ghana? Do you share the view that we should criminalize unexplained wealth in Ghana?
It is a bit too, Honorable Chair, it is a bit too overbroad to state more focused and clearly delineated because of the specter of someone ending up in jail, losing his liberty, or being fined heftily for an amount. And so if we are to place it in proper context, unexplained wealth, I would say that if the person cannot reasonably explain as matched against his lawful income, the amount of money that should be allowable, that should be acceptable. So in your context, unexplained wealth will be reasonable explanation of the source of that property, wealth, or funds.
Chairman, just to take the nominee, I appreciate your response to it. If you take the United Kingdom today, where Ghana largely borrowed its legal system, largely, they now, for purposes of combating economic crime and fighting corruption, have what they call a reverse burden of proof, that the onus must shift, that when those assets cannot be explained for, an irrebuttable presumption is that they are acquired illegally, fraudulently, it may be taking advantage of the state and its resources. So they now go for a reverse burden of proof. Will you subscribe to that for Ghana in our quest, our collective quest to fight corruption? Thank you, Chair.
Honorable Chair, I'll link it to my answer to the first question. Also pointing out that criminal constructs are very, very dangerous if not well thought out. A reverse onus clause, as the honorable member rightly put it, puts the burden on the accused person to explain to explain one way or the other the charge against him, rather than the prosecution bearing the. If the construct here is that you cannot reasonably explain as to how you came by that wealth or property matched against your lawful income, then it presupposes that I have already placed the onus on you to show as to how you came lawfully in possession of that wealth, property, or funds. So in that context, my answer will be yes.
So, Chairman, still there. Why every country that is committed to fighting corruption has asset declaration regimes, and the essence is that you should be able to match incomes, legitimate and lawful, with unexplained wealth. Now you have this 9 million in the account of a public official, and maybe 3-4 years back, that money was 9 million in his account. If you were a special prosecutor and that was brought to you, your attention by an ombudsman in the republic, what would be your attitude to dealing with this matter? Thank you, Chair.
Honorable Chair, as I stated, it should be matched against your lawful income. Forest area somewhere, and he earns money from it. That will be lawful. So whatever the source of the income is should be lawful. So the aggregate...
So accepted, Chairman, accepted. So now, is it not a case that the state could say, okay, come and explain to us in the context of the British system how you got this 9 million? That's the reverse burden of proof. The proof beyond reasonable doubt is no longer going to be the onus on the state. But we cannot explain how come you have 9-10 million as public official in your account. And legitimately, there's nobody in Ghana from the president through ministers of state, except those undertaking businesses, who should have that quantum of money. You are to help us fight corruption. Wealth that cannot be explained. We want you to be the lead police in
is secretive and very, very complex. And most of the time, it transcends national boundaries. And unless the participants of the corrupt activity are opening up to you, it is very, very difficult to, on your own, establish that these funds came about unlawfully. And so, as I keep saying, if I were to place the burden on you, matched against your lawful income, and you cannot reasonably explain as to how your lawful income falls short of your wealth,
how prepared are you to fall into the heavy shoes of Martin Alamichi Hamidu, given his enormous experience in the background? Many have referred to your age so far. Reading your CV, I'm encouraged that if you would be fair, firm, and courageous, we'll get somewhere. Now, it's indicated that the most veritable source of corruption globally, and particularly Ghana, is the abuse of conflict of interest. And many situations of unethical behavior is associated with persons' conflict of interest. What strategy do you have? People want to reward family and friends, want to reward other persons. Sometimes corporate entities that are formed overnight will win contracts and bid against very experienced hands in the name of conflict of interest and its abuse. What will you do as special prosecutor to give respect to the provisions of the Constitution on conflict of interest and barring public office holders from abusing that opportunity? Thank you, Chair.
Honorable Chair, there was a reference to heavy shoes of a named individual. Honorable Chair, I'd like to state that I prefer to wear my own shoes. In the sense that I am my own man and I'm coming with my own experiences and professional training. In this quest, my conscience and my learning of the law are going to be my guide. My strategy is that, Honorable Chair, I'm not naive to assume that I'm coming to stop corruption. There is no way I can stop corruption. God himself. First, I'm going to institute what I call pressure for progress. And in this quest, there will be a systemic review of all public agencies.
What was the word you...
I said I have termed it pressure for progress.
Pressure for progress.
Yes.
Very well. I thought it was a Latin word you spoke. I didn't get it out.
I'm going to institute systemic reviews of public sector institutions and the development of integrity plans. And here, this is what I intend to do. Why can't we have our own corruption perceptions index, for instance? Why can't I rank public sector agencies against each other and at the end of the year publicize the results as to which institution is performing well and which institution is not performing well? In that quest, if you are head of an institution and persistently your institution is drawing the short straw in terms of you will set up. Because
Special Prosecutor, you are aware that you are being appointed to operate a particular law. Where will you draw your authority to be publishing perception, corruption, or corruption perception index of agencies? Where under the law will you have that your authority from?
Now, the Act empowers me, if I'm given the nod by this House, to institutionalize risk assessment in respect of public agencies. And in doing risk assessment in terms of the activities of public sector agencies, it is a form of institutionalization of that systemic review of their activities. The Act also empowers me periodically, if I'm given the nod, to publish the activities of the OSP and the operations engaged in. In line with this, it is an offshoot of the mandate of the OSP that I could go ahead after the process of risk assessment, integrity of every public sector agency, to then come out with my results as to who is doing well and who is not doing well. It is an offshoot of that mandate.
Are you done with answering his
No,
question?
I'm not done.
Continue with that one and other members will come in.
From the Act, Honorable Chair, 4 divisions have been created therein: finance and administration, prosecutions, investigations, asset recovery and management. I intend to create 2 more divisions to give more teeth to the OSP office if given the nod. The Act itself envisages that the OSP can create more divisions if it so desires. And I'll be adding 2 divisions. One, a strategy and research division.
Chairman, just hold it there. I'm not interjecting. Go to section 19 of your Act and make appropriate references for our purposes. You are just special prosecutor. The law assumes that you have a board. And in answering the question as chairman posed it, the mandate is not just yours. So reference the board for our purposes, for our record. You only can create additional divisions with the concurrence of the board. Is that not legally accurate? Am I not accurate?
It is so, Honorable Chair. I believe, my apologies, but I believe I said the OSP. So when I said the OSP, it wasn't in reference to a person but the office. So the aggregate of the office, including the board. That is the context in which I placed it. Yes. May I proceed?
Very well. Yes. Honorable Gaga.
Mr. Kissi Agyebeng, congratulations. Honorable Chair, just to place on record that the Honorable nominee actually handed over to me as legal secretary. If you go through his CV, and so I'd like to congratulate him. But having said that,
Being a consideration of the OSP, would you consider yourself in a conflict situation?
not at all, Honorable Chairman. not at all. Yes, but it's important to make that disclosure. Yes. Yes, having said that, Mr. Agyebeng, when you were nominated as a special prosecutor by the Attorney General, I chanced upon an article written by a man who would be your predecessor if this committee gives you the nod. And in that article, you have been described in language that is not too palatable by the said former special prosecutor. Now, in it, he says that Mr. Kissi Agyebeng is a surrogate of a law firm. Then he goes on to further implicate you as one of the key architects of the botched Ejapa royalties transaction. Now, if you juxtapose these allegations with the role of special prosecutor as an entity that ought to be independent, you have your would-be predecessor, that is, if given the nod, describe you in such language. Honorable nominee, what is your take on this? Are you a surrogate of anybody?
Honorable Chair, I think before I go on, there's one more disclosure that I have to make in respect of Honorable Member Bulsa North. I was actually the chairman at his wedding reception.
Chairman was, Honor Agaga, Chairman was right. That he almost said that, yes, I do on your lips too.
Honorable Chair, if I may answer. Whoever says I'm a surrogate of a law firm or implicates me in the Japa transaction clearly does not know me. Because if you know me, you wouldn't make such allegations. And so all these things that came up, I took it as coming from uninformed positions. Because I was not involved in the Japa transaction in any form or manner, by any stretch of the imagination, however fertile. As for relationships, as I just disclosed, the fact that I was so close to you at some point in our lives will not give you, or you not give me a free pass because of that relationship. And that is why I'm here. And if there is a matter, I'm not going to say because I know one person or the other, I'm going to give the person a free pass. I certainly will investigate. But the truth of the matter ought to be told. I wasn't involved in the deal. I was nowhere near it. Indeed, until it started coming up, I didn't even know what it was. For the record, that is the truth. And so I'm no one surrogate. As I said earlier, I'm my own man, and I prefer to wear my own shoes. If the law firm was named, it would have even been fair to me. But if you say I'm a surrogate of a law firm, clearly you don't know me. I ran my own law firm. I've been running it since 2014 as a managing partner. I cannot be described as a surrogate of that law firm or any other law firm. Honorable Chair, that is my response.
Now, Mr. Agyebeng, you have also been described as a very young and inexperienced lawyer who is not fit for purpose. For, you know, these are descriptions that... Honorable nominee, what is your reaction to this? That you are too young and naive to be appointed to occupy a position such as the Office of Special Prosecutor. Are you, let me ask you this, are you experienced enough to occupy the position of Special Prosecutor?
Honorable Chair, first, the age. I turned 43 years on 2nd July, a few weeks ago. I qualified to be the President of this Republic. I am age mates with the President of the French Republic. Indeed, he should forgive me for saying this. I'm a year older than the Minister for Justice and Attorney General. We were mates at the University of Ghana and Ghana School of Law. He is the Minister for Justice and Attorney General. There's no question about his age. Why then throw issues about my age? In terms of experience, as I stated much earlier, I was called to the bar some 18 years ago. I qualified to sit on the Supreme Court of Ghana. Indeed, I'm 3 years past the qualification for Supreme Court. I have taught criminal law, especially in the University of Ghana, for 15 years, continuously. I see, if I'm not mistaken, some of my former students around this table. Honorable member for Ejuso is my former student. Honorable member for Medina is my former student. Honorable member for Kaikwe Central, I was their TA in conflict of laws. These are the products of my experience. They are here, right here, for everyone to see. And, Honorable Chair, to anchor on that, I have had a front row, although I have not been a prosecutor, properly so-called. I have had a front row to landmark prosecutions in this country. As defense counsel, I have been engaged in some very landmark cases, including the Tagore case, the Baglas Kanko case. I conducted them. Honorable Chair, when Tiger IPI and Arumia announced come up with their investigative pieces, I am the one who supervises, and I've been doing this for quite a while. supervises the collation of evidence and all that for presentation to the Attorney General. Without me, the Attorney General's office will be poorer in terms of those prosecutions. So I can go on, but my experience is out there. And going beyond this committee to the bigger house, I think the honorable member for Old Tafu was also my former student. My experience is out there. It's on record.
Yeah, Honorable Nominee, the Office of Special Prosecutor derives its mandate directly from Article 88 of the Constitution, and that article is the one that vests the prosecutorial powers of the state in an Attorney General. Now, do you envisage a situation whereby the functions of the special prosecutor would conflict with the functions of the Attorney General, given the fact that these are functions largely derived from the constitutional powers bestowed on the Attorney General?
Initially, I would like to believe, Honorable Chair, that when this process started, you could tell that there was a clear and happy friction as to how it was going to go. And so some of us even pointed out to the then Attorney General, informally then, actually, that, I mean, as a lecturer of criminal law, when you see some of these things, you would have to tell those in authority as to how things should properly go. There was a concern of this friction between the Attorney General and the OSP under Act 959 because of the way Article 88 has been couched. Because it gives all prosecutorial powers to the Attorney General, but then, by way of delegation, the Attorney General can delegate a person or institution to carry on prosecutions. So what the draftsman did in Act 959 is a sort of taking that discretion under Article 88 from the Attorney General, putting it in Act 959 and saying that the OSP can prosecute on the authority of the Attorney General. It is stated in the Act. And so by that formulation, from the onset in the Act, the OSP already has the authority of the Attorney General because Parliament has said so. But that would not end the story if more delineation is not done. So it appears tenuously, but the draftsman also tried to do something in Act 959 by specifying the offenses the OSP can investigate, can initiate, and conduct prosecutions in respect of. That is corruption and corruption-related offenses. There is a problematic one, the last one, which says existent offenses in relation to corruption and corruption-related offenses. It's problematic because if it is not well thought through, then a lot of friction could arise there. The reason is simple. There are two main forms of offenses that may arise in this regard. One, we have what we call predicate offenses. With predicate offenses, these are offenses which forms component parts of a bigger offense. And so if the OSP is prosecuting an offense, but its component is not clearly delineated in the Act, in Act 959, and it is in the province of the Attorney General, some friction may arise there. And then the other form of offenses I would refer to as antecedent offenses. Let me give an example of the first one, the predicate offenses. For instance, corruption as an offense could have a predicate offense like money laundering. But money laundering is not specifically stated in Act 959. So the OSP can then go to the umbrella and say, okay, these are existent offenses that arise or are consequent upon corruption. There, the Attorney General could also say, look, money laundering is my province and not yours. That is what I mean. Then in respect of the antecedent offenses, these are offenses that are committed before a major offense itself is committed. For instance, if we take the offense of dishonest receiving under Act 29, something must have occurred before someone receives or disposes of property. That is to say, if you are dishonestly receiving, you are dishonestly receiving property that is the proceeds of a crime. It means a crime must have already been committed in respect of that property or funds for which you dishonestly received. If the antecedent offense has not been committed, you do not come in charging someone with dishonestly receiving. And in respect of the antecedent offenses, problems of friction could also arise in respect of the Attorney General. But I see that Draftsman also tried to do something under Act 959. He said, the OSP, within 30 days after the end of a proceedings, should inform the Attorney General as to the case, its outcome, and all. But I think this can be solved by properly defining, in my opinion, the jurisdiction of the OSP. And here I would advocate that we should start thinking about, if I'm not being overbearing, the passage of a Corrupt Practices Act, which will capture all these things, spell them out properly, define them properly, and the roles will become clearer. Because I'm foreseeing that in the future, serious friction may arise in respect of these umbrella offenses if the thought process is not clearly deliberated on. That's my response, Honorable Chair.
Yes, John Puma. Now, the students
Thank you very much.
Their lecture questions.
Yes, thank you very much, Mr. Chairman, and let me take the privileged opportunity to congratulate my lecturer. Mr. Kissi Agyebeng was one of the favorite lecturers on campus for us as law students, and I want to congratulate you for the nomination. Those of us who know you believe in your competence and what you can deliver for this country. So just rest assured that you have our backing. I have a few questions to ask you, though. Well, this one is now fulfilling my duty as a member of parliament. So, as a defense lawyer, I mean, you have taught us criminal law. We know your inclination to defense. And you have practiced as a defense lawyer for quite a long time. And I'm happy you refer to some of the famous cases that you've been part. How well are you positioning yourself to now transition to be a prosecutor? Since if you look at your track record, your first inclination is to now look at the defenses possible in the act. Now you're supposed to be the prosecutor. How well are you now going to transition yourself to go after the actions rather than defending it?
Honorable Chair, Let me take a little swipe at the honorable member. If you would remember in tutorials, I always said, be neutral, be in the middle as an arbiter. And that is how I've conducted myself all this while. Of course, when I take my defense cap and I wear it, I'm coming all out to defend my client. But then, I have switched sides so many times, as I alluded to the fact that, for instance, in the announced cases, I'm not on the defense side ever. I'm always on the prosecutorial side because I have to give the primary information to the Attorney General's office to run with it. It's like a baton. So I have had experience with that already. And because of the way I've always conducted myself in these things, it will be second nature to me in that regard. It is not new. It won't be new. And I'm ably placed to do that.
Great. Mr. Chairman, office, up to section 46, it appears almost the same provisions are provided in the Act 804, which is for the Economic Organized Crime Office Act 804. You are given the powers of seizure, the powers of search, the powers to freeze accounts on suspicion of corruption, among even powers of confiscation to aid your investigations. And you even have 7 days where you can seize property or power before you go to court for confirmation of your orders. All these are also provisions in the Act 804. One of the nightmare of any lawyer, a practicing lawyer in Ghana, is where you are in court with, say, Yoko, and then BNI, which is now NIB, and even similar provisions is also found in the Financial Intelligence Act. So FIC could also invite your client. On the same provisions, the Office of Special Prosecutor is also mandated by this act to call your client. What will be your advice as a special prosecutor in instances where your powers as defined in the act conflict with the same provisions in other acts as I've referred to?
Honorable Chair, the advice has come by way of statutory provisions in the Act itself. Because Act 959, in Act 959, Parliament says there in the Act that we should cooperate. Otherwise, it will be totally duplicitous and unfair to suspects. I think the reason why the other agencies act the way they do is because they don't have the final push of prosecutorial powers. Because they would have to refer their dockets to the Attorney General's department. But in this case, everything terminates with the OSP. And so, in that sense, it is a bit different and unique from the other agencies like the FIC, Yoko, NIB, and Anshraj, for instance. Yes. Since the Act itself is telling all these agencies to cooperate, that is how we need to go. Otherwise, one agency is doing something, another is also doing it. If we don't cooperate, for instance, suspects can easily walk through any crevices we will provide. They will gladly walk through because we are not cooperating, we are not comparing notes. If we cooperate and compare notes, then one agency can see its way clear to say, this falls directly within my province, and I should take it up, and the other agencies would have to let go.
Mr. Chairman, there is a raging legal debate in jurisprudence on law of evidence, on admissibility. Two schools of thought. One school says that evidence is evidence. It doesn't matter how you procured it, even if you stole it. It must be admissible. And in fact, in Ghana, some people refer to it as the Anas principle, where it does not matter even if you were deliberately set up to commit a crime. It is okay. That's one school of thought. Another school of thought questions the legality and the process of procuring such evidence and describe it sometimes as a blackmail or unconstitutional on the rights of the accused persons. These scenarios exist in different countries. In America, for instance, they don't accept the first scenario in cases of Mapp versus Ohio. In India, several lines of cases reject illegally acquired evidence. But when you come to our jurisdiction, and most of the Commonwealth common law jurisdictions, our laws are not clearly defined on whether illegally acquired evidence must be admissible in our courts. As our special prosecutor, and especially with your background in your private practice, with more associated with the Anas principle, in a democratic environment as we have in Ghana, now that you are going to be the Office of Special Prosecutor, how are you going to marry these two schools of thought to ensure that constitutional rights of even accused persons are respected and fairness prevail even in such circumstances?
Honorable Chair, foremost, the Anas principle is not akin to illegally acquiring evidence. It's a different matter. But since time immemorial, Honorable Chair, I agree with the Honorable Member, this debate has been raging. But in recent times, I do believe that our Supreme Court has sought to bring some harmony in respect of these two competing theories that are fighting for mastery. And it has placed it in a more clear contest in terms of what will be acceptable and not what will not be acceptable. So the general rule will then be that, from my reading of all these decisions, the general rule will then be that, and that is how I'm going to go anyway, that if I'm giving the nod, that ordinarily, that's the general, ordinarily, evidence illegally procured will not go in. But then there are accepting circumstances. It depends on the exigency of the matter and the seriousness of the occasion. For instance, if we were to see someone committing blue murder right in front of our eyes, and we videoed him, like what happened with the infamous George Floyd case, are we going to say when the video was being taken of those officers because it wasn't with their consent, the court should not accept the evidence because their privacy was being breached? In that situation, a life was being taken, and it trumps the person's right to privacy, the person who is committing the crime. It trumps his right to privacy. So all said and done, we situate it in the context of a balance. How do you weigh it? That is how we're going to go. How do you weigh it? And if the evidence trumps the rights of the perpetrator, it should be accepted.
Well, Mr. Chairman, just a follow-up question.
No, you're done. Yes, Honorable. Thank you very much. Mr. Kissi, on your nomination, let me congratulate you. In your earlier responses, you touched on the relationship between the Attorney General's office and the Office of the Special Prosecutor. I see in the enactment of Act 959 that we try to provide some sort of veiled amendment of Article 88 of the Constitution, using specifically 88.4, that says that all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with any law. So I assume that the amendment or the passage of this act is hiding under the phrase in accordance with any law. But can you, given your experience as a criminal law lecturer, and I believe being a law lecturer, you do remember your constitutional law also. Can you tell me what you think about Article 88.3 itself? 88.3 itself, which says that the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. Is that the clause that we ought to have been amending?
Honorable Chair, as I stated earlier, it is clearly problematic constitutionally. And as I said, some of us expressed our views informally to the then Attorney General as to the constitutionality of the creation of the OSP. And Article 88.3, as you have identified, is the mother of this problem. And what Parliament has done is it tries to then marry with this provisions in Act 959. It tries to marry in a sort of sidewind fashion 88.3 and 88.4 by just giving the authority of the Attorney General, whether he likes it or not, in that sense, if I may be obtuse, to the OSP. So, to prevent the situation where the OSP will then be always going to the Attorney General to seek his or her authority to initiate and conduct proceedings. And that is why I said that it appears then when the draftsman saw the mischief, that he hadn't really solved the mischief. He then at the back said, okay, when you finish, tell the Attorney General what you have done. There's still more work to be done. There's still more work to be done on this.
Work to be done by who? Parliament or you?
Honorable Chair, it has to be Parliament with my input and help when I'm giving the nod that we need to clean house properly to make things clearer. As I kept saying earlier, that friction may arise one day. Friction may arise one day if, for instance, the sitting Attorney General and sitting OSP do not see eye to eye really on a certain matter. Serious problems may arise. Honorable Chair, I agree with you. It should have been, if they may forgive me, better thought through. But with what we have, it is food that is still edible. Maybe we can garnish it later, but we can still eat what we have now.
Chairman, which food? This one with salt or without salt?
Honorable Chair, being a Kwauman, it can only be fufu and cracker.
Chairman, if the Honorable Ayarga will accommodate me. So, lecturer, conflict of laws. What conflict have you seen between a constitutional provision and an act of parliament? Where should the hierarchy of respect be, in your view? And what should we do the way forward? I like your thinking on this matter, but go further. What should we be doing in order to realign the provisions of the Office of the Special Prosecutor Act consistent with Article 88 of the 1992 Constitution? Thank you, Chair.
Honorable Chair, of course, every law student knows that the Constitution takes precedence. But what should we do? I think I've intimated to it. The mother problem is 88.3. That is where the issues appears to be. And so if we are able to amend 88 in such a way as to lessen its mandatory language in that context, to allow other agencies to perform such a function, because in practice, I would like to believe from my experience that Attorney General's office is already inundated. And so these satellite agencies will need to augment.
Chairman, just a little clarity. So are you for a constitutional amendment to Article 88, or, to quote your words, cleaning up the OSP Act? Where do you stand? Are you advocating for review and amendment of Article 88, or specific to the Act? Thank you, Chair.
Honorable Chair, I'm not just limiting my sights to the OSP. I was also transferring it to other agencies, like the FIC, the IOCO, and all that. So all these acts, together with Article 88, must be thought out again and clean house.
Yeah, okay. So related to that and the federal house cleaning exercise that we may need to do, from your reading of the Constitution and then Act 959, do you foresee a situation where one will say that the mandate that is given to the special prosecutor is actually not exclusive, and that any time the Attorney General's office can take on any case that has to do with corruption, and also, parallel to whatever the Office of Special Prosecutor is doing, also prosecute those cases, and that we haven't really given an exclusive mandate to the special prosecutor?
Honorable Chair, the attempt was made, but the job wasn't finished. And it's because, once again, you had the problem of Article 88.3. It was difficult to go around Article 88.3 to exclude the Attorney General from it. And I would say Attorney General shouldn't be excluded from any criminal proceeding in that sense. Because of the way Article 88 has been couched, it was impossible then in 959, when the mandate of the OSP was being spelled out, to then say that the OSP has exclusive jurisdiction in respect of corruption and corruption-related offenses, and no one can come close. It was just impossible to do that because of Article 88. But with experience, Attorney General should always have an interest in terms of what is going on in respect of the conduct of criminal proceedings, investigation of criminal proceedings, initiation of criminal proceedings. Because at the end of the day, he is justice. Attorney General is justice. Everything any other agency does. In truth, the OSP is specialized, and it has a more focused approach to things. But whatever any agency does, it is to justice. And being Minister for Justice and Attorney General, that office should not be expressly excluded from criminal proceedings, conduct of criminal proceedings in that regard. So I won't go that far, but I will say we need to, once again, repeating myself, clean these things up in the general scheme of affairs to make things more clearer.
I think this is my last question. Yeah. So my last question relates to a function of the OSP that I don't think conflicts with the constitutional provisions relating to the Attorney General, and that has to do with fighting corruption. I think the issues with the Attorney General has to do with initiation of criminal proceedings. But before initiation of criminal proceedings, every other function, we can legislate that anybody can do that. So in the area of fighting corruption, what do you think you can do? You've just mentioned corruption perception index ranking of public agencies. I think that under Section 2C, you are to take steps to prevent corruption. Naming and shaming can prevent people from engaging in the conduct. So I think that you are well grounded in Section 2C if you do corruption perception index ranking of public utilities, public agencies and institutions. Beyond that, what new ideas do you have in terms of your functions under 2C, the objects of the office, to take steps to prevent corruption?
Honorable Chair, I think it should be obvious to everyone that we cannot fight corruption solely through the criminal law. It is also because we live in a society of ritualistic gift giving. If you happen to have the unfortunate situation, just by way of illustration, unfortunate situation of having your back wheel land in a gutter and someone comes to help you out, the person is expectant that you will give him something. This society is, this is what we thrive on. It is a ritualistic gift-giving society.
I'm saying that it's not just your vehicle landing in the gutter, but in the case of MPs, even if he greets you, he expects a gift.
You see where the problem lies. And because of that, it is very difficult to distinguish the acceptable from the unacceptable. And this is what is informing my drive if given the nod. That if I were to just focus on the criminal law aspects, that is to say, prosecution, I won't go far.
Quickly, do you have any agenda in relation to election campaign financing? I'm trying to focus the question. Trying to focus the question.
Thank you. You're done. Now, Obiamo first. Yes.
Thank you, Mr. Chairman. Congratulations, Honorable Kissi Agyebeng. You are famously known to be a very good criminal law lecturer and also a practitioner as far as criminal law is concerned. Now, we seem to have spent some time on the mandate of the office. Going back to the Act 959, specifically Section 4, where the mandate of the office is spelled out. And as you seem to allude, if the ordinary man wants you to explain to him what you are required to do as a special prosecutor, how would you put it? Especially where the impression has been created that your office is more or less not required or necessary, given that you fall under Article 88. I'm asking this specifically because of Section 4. Because the impression is created that you fall under only 4.2. But if you look at even 4.3, it will expand your mandate. And probably we may not say that this office is not too necessary because of Article 88. Yes.
Honorable Chair, interestingly, when my name came up, my own kids were asking me, so Daddy, what is it that you're going to do if you're given the nod? In simple terms, the office is to investigate, prevent, prosecute for corruption, and manage seized, frozen, or confiscated property. But, Honorable Chair, in terms of the relevance of this office, the day we scrap this office is the day we say goodbye to our fight against corruption. Its relevance is borne out by its attributes and its uniqueness. It is unique as compared to all the other law enforcement agencies in respect of its mandate, because no other institution has been carefully thought out and designed to fight corruption specifically as Act 959 has done. And, Honorable Chair, in respect of this, the Office of the Special Prosecutor is the gold standard under the UN Convention Against Corruption and the African Union Convention on the Preventing and Combating of Corruption. The international community, including Ghana, we ratified these conventions way back in the early 2000s, I think 2002 if I'm not wrong, that every jurisdiction requires such a specialized agency, which should be made independent, with a specialized trained staff to focus on the fight against corruption. Now, the, if I may say, flaw with Article 88 in terms of the Attorney General is that we sometimes require too much of individuals occupying the office of the Attorney General. Come to think of it, the Attorney General is a member of Cabinet. He is part of the government. How independent would he be in terms of certain individuals if they were to fall foul of the law, if, for instance, they are also members of Cabinet or members of the government? But in respect of the OSP, an agency, a person manning it, who is not part of the government machinery, who is independent, and Honorable Chair, if given the nod, I'm going to guard my independence jealously, who is resourced to undertake.
Honorable, in your family tree, how wide is your family tree?
It's an ending, actually.
Very well. So if you start from guarding your independence against them, your family, then you can guard it against everybody else. That's my charge to you.
Thanks for the footnotes.
Chairman, if I can just honor Obi, if you accommodated me. So, Kissi Agyebeng, just to get your own words, how independent will you be from the Attorney General, from the President of the Republic, and from friends and family members? Thank you.
Honorable Chair, so far as I situate myself squarely in Act 959 and its four corners and province, my independence is assured. If I go beyond it, then I'll be on my own predilections. But the Act itself expresses it in so many words, and that should be enough.
Yes, Honorable, are you done?
Thank you. I would like us to look at Section 71 of the Act, plea bargaining. How do you think this aspect of the law or the Act can be implemented without the impression given out there, especially given your position, that this area can be compromised?
Honorable Chair, fortunately, there is an arcane provision in the Courts Act where the Attorney General is also given the power to plea bargain by some sorts. The person pleads guilty. Person he coughs up the money, disgorges himself of the unjust arrangement, and the state is happy to keep the money. Enter a sentence of conviction against him, but he doesn't serve a prison sentence. It is not unique. We already have that practice instituted. And clearly, this is meant to put some money to make that activity costly. So, Honorable Chair, we already have a precedent in the Cost Act for this.
Yes, the last one is about.
This will be your first.
I have heard some board members making comments about investigations of OSP. Would you say that, given the role of the board, they should be allowed to make comments on investigations which are being made by the office? And what are the implications of that?
Honorable Chair, the board is not supposed to interfere with investigations and the conduct of criminal proceedings. The SP, the Special Prosecutor, of course, answers to the board. But the Act itself clearly insulates the board from the investigation, conduct of criminal proceedings, and places it squarely in the province of the Special Prosecutor himself. So in that regard, the board should refrain from making comments and passing, let me say, judgment on ongoing investigations, because there is a high risk of a compromise. Leakage of information may arise, evidence tampering may arise, and it is in that wisdom that Parliament insulated the board specifically from initiation, investigation, and conduct of criminal proceedings.
Yes. No, let me give to Zura first.
Thank you, Mr. Chairman. And good afternoon, Honorable Nominee. Good afternoon, Mr. Chairman. Thank you very much for the opportunity, and good afternoon, Mr. Nominee. Mr. Nominee, before I go to my question, please, where is Damfa in Ghana?
At Imensa, you take the right down through Kweman to Damfa.
So that's still in Greater Accra region or Eastern region?
That will be in Greater Accra.
Greater, all right. Thank you very much. Now, my first question to you, Mr. Nominee. In September 2013, at a symposium organized by the Dankwa Institute, you presented a paper. And the paper was titled, "The Decision That Wasn't the Decision, a critique of the Supreme Court decision in the election petition case," unquote. In this paper, you argued that the decision by the Supreme Court was somehow erroneous. You argued in the paper that the decision was somehow erroneous. And that, how do you juxtapose that position against the 2021 election petition hearing of the Supreme Court, where the EC chairperson was not made to testify under oath, which was actually central to the position of the NDC in filing that case? What are your thoughts on the Chief Justice's actions in reference to Honorable Dr. Dominic Ayini's comments, which were very close to...
Kindly take it one after the other. You answer one. You're putting two separate issues in one question. Break them up, please.
All right. His comments after the decision, which the Chief Justice took exception to, and was cited before the General Legal Counsel. What is your position in view that your comments, very similar to his, were never cited before the disciplinary committee? Thank you.
Yes.
Honorable Chair, Honorable Ayine is my senior in chambers. Actually, he taught me commercial law, the Faculty of Law then. But I would say here that, before I answer the question, the comments are dissimilar. They are dissimilar in the sense that in 2013, when I had a paper at that symposium, it was an academic paper that presented. And my conclusion was that I couldn't find a ratio in respect of the so-called majority judgment in the first election petition case. And my reason was simple. Some issues had been placed before the court. Two main issues, in my opinion, as to whether, number one, the second respondent then was validly elected as president, and number two, as to whether the first petitioner then was validly elected as president. At the end of the day, when I read all the decisions of the 9 justices, I couldn't dovetail it with the outcome that was stated by the president of the court on that day in August of 2013. And this is it. It appeared to me, and as I said, this was an academic paper, it appeared to me that instead of answering the questions that had been placed before the court that day, the court missed those questions and was answering different questions. So whether or not the second respondent was validly elected, that wasn't answered. But what was being answered was, for instance, whether there was overvoting, whether there was voting without biometric verification. So instead of the president of the court stating on issue 1 whether the second respondent was validly elected, president of the court was rather stating how many judges voted on overvoting, 6-3. How many judges voted voting without biometric verification, 5-4, and the like. And to me, as a law lecturer, I didn't know what to teach my students at the outcome, because I'm seeing 5 justices saying that someone was not validly elected, 4 justices saying at the end that someone was validly elected, but I'm being held to say that the 4 justices were in the majority. Because I couldn't find a ratio in that case, that is why I made that academic exposition. And in respect of the 2021 decision, in terms of the comments by my former senior, I actually had cause during the pendency of the first election petition to deliver another talk before this talk you referred to. It was organized by the CDD and the National Media Commission. And there it was in respect of free speech and accountability and the rule of law. If we will recall, several individuals, private persons, had been hauled by the Supreme Court and cited for contempt. And my consternation was that it appeared as if immediately your name was cited and you were hauled in before the court, then you needed to start apologizing. And so those who apologized immediately were let off. Those who decided to bring in lawyers to defend them ended up in jail. And That was what I was pointing out in the first paper before this paper you referred to. Indeed, at that time, the bar took umbrage at what I said, but I thought that I captured the conscience of the nation better by saying that, look, this whole issue of contempt as a criminal offense is so dangerous that if we are not minded to codify it, to define it well, and to come up with commensurate punishment, we will get to a situation where it will not be on national TV that day, but a high court judge sitting somewhere in Goso, there's no camera on you, cite you for contempt, jail you for 15 years. All you have to do will be to appeal. So I was sounding that caution, and that where we were going was very slippery road, and so we needed to rein ourselves in.
Honorable, before you come to this, let's go a little back into how did the concept of contempt of court develop? Was it by statute? It is never by statute.
No, it was.
The courts generated that to protect themselves from executive abuses. Parliament generated its own contempt to protect itself from executive abuses because they have powers, they have the agencies of force. The courts don't have. The Parliament doesn't have. So these two arms of government developed their own jurisprudence of contempt to protect the two institutions. So now, are you suggesting that Parliament should now make rules regulating how the court should now exercise their power of contempt?
Honorable Chair, absolutely. That is what I'm suggesting. It is dangerous, no matter how you look at it, if we are just to leave it the way it is. It is a common law offense, which has been accepted under the Constitution. But the danger, as I pointed out, is that because it does not have defined punishments for it, the punishment at some point may not fit the crime at all. And that is the danger. Because if you were to be cited for contempt today and say the judge gives you 2 weeks in jail, maybe you were let off. Same act placed before another judge may fetch someone 2 years. How do you justify that? It is a simple matter, in my opinion, of just delineating it. Okay, this act amounts to contempt. And in respect of this, if Parliament or the courts were to cite you for contempt and hold you liable, within these 4 corners, we can hold you liable. Honorable Chair, I think it is a safer course to go than to leave it open as it is. There is a clear and present danger.
Well, that's why we continue to have different opinions. But I didn't finish answering her question on Honorable Aine.
I believe I finished.
You're done. Very well.
Thank you very much, Honorable Chair. Honorable Nominee, my second question has to do with a report by the Center for Social Justice, which suggests that Ghana has lost up to 1.89 billion cedis in judgment debts. There's a school of thought that intimates that these judgment debts sometimes are not particularly due to bad contracts being cancelled, but due to schemes that have been cooked up by senior public office holders, sometimes in collusion with international organizations, with local companies, just to fleece the state. What will you do? How do you think your office, the Office of the Special Prosecutor, can work towards eliminating this canker so that Ghana can save a lot of money? Thank you.
Honorable Chair, I believe I answered this question earlier when I intimated that our institutionalized risk assessment, conducting regular risk assessment in terms of the avoidance of toxic deals. That is what you referred to. These are toxic deals. And also the avoidance of judgment and tribunal award debts. And then I also intimated that I would do a systemic review of public sector institutions and the development of integrity plans. And that is where I waded into my corruption perception index idea of anti-corruption barometer of state agencies. That will have teeth and it will bite.
Thank you very much. My final question. A lot has been said about your age. And you've alluded to your experiences up to this point, which you think will be a good guide for you in undertaking your job in this office. How will you, however, navigate our cultural settings where we revere our elders in society, we revere the big man, we revere our chiefs? In terms of prosecuting your work, somebody is under investigation, goes to see Nana or Bahima, she calls you. How will you manage this within the context of our Ghanaian settings? Thank you.
Practically, simply, I'll have less friends. And that is why I alluded to my earlier statement that in the society of ritualistic gift-giving, gifts of goodwill, it becomes very difficult. And so just a reliance solely on the criminal law is not going to make it. Some practical, innovative things must come on board. If I start by having less friends, if I start by not picking calls, you will not approach me easily. But I admit, honorable member is fascinated by it. I'll admit that, of course, if my village chief calls me and asks for a favor, it will be difficult. But, sorry? Oh. Yeah. It will be very difficult not to attend the call. But I said earlier to in answer to an earlier question that if I place myself within the four corners of Act 959, I should be much more insulated from these things. But if I go out of it, then I open myself up for Jantua.
Very well. Honorable Minister first. Deputy Minister for Education, is that right? Yes. In that order.
Thank you very much, Honorable Chair. Congratulations, Mr. Kissi Agyebeng. It's amazing how you would drop one of my favorite names, William, which also happens to be the name of my father. Maybe you may consider transferring it to one of your prospective kids in the future. But I must congratulate you again and going through your CV, the sterling legal credentials that you have, and listening to you, particularly on the innovative methods that you intend to deploy in the fight against corruption. I'm confident that you would succeed in the discharge of your mandate. However, there are just two concerns that I want us quickly to address. The first is your predecessor, when his nomination came up, was met with very high public expectations, just as your nomination has also been met with. But the public have very high confidence and high expectation in your delivery. However, some have held the view that your predecessor was unable to fully discharge his mandate and even to full term. So what assurance can you give this committee that when given the nod, you will see through the discharge of your mandate fully, and that somewhere along the line you won't throw in the towel should you encounter some challenges?
Honorable Chair, if I see through this office, I will be leaving at the end of a 7-year tenure on my 50th birthday. The gift I want to give myself when I turn half a century is that the OSP, solidly established, methodologically run in its deliberations, and its mandate is firmly placed on the map, that we may even become a beacon for our sister countries in our region to look up to. That's the gift I want to give myself for my 50th birthday. And so, my assurance to you, Honorable Chair, I'm going to see it through.
Very well, Honorable Chair, that would be a good legacy and a good gift, and I would encourage you to pursue so. The second and last concern here is that among many other criticisms that your predecessor publicly raised, one of it is that he alleged against you that you're representing some persons whom are under investigation by the Office of the Special Prosecutor. Now, when given the nod, which I'm confident about, how would you handle such matters in a way that you will not be conflicted? And how would you specifically handle such cases under reference?
Honorable Chair, once again, this appears to be a bit of a flight of fancy. It is not, if I may put it, true to say I represent persons who are before the OSP as suspects. It was in respect of one matter in which my firm represents a company, and the CEO of the company was invited to come and assist the OSP in respect of some investigation in the award of some contracts that the company did not award to itself. On the day that we appeared with the CEO of the company, the OSP could not meet with the person to interact with him. The meeting never came on, and as we sit here, it has never been recalled. So, in that context, you cannot say that I represent suspects before the OSP. Once again, as I said, it's a bit of a flight of fancy.
Thank you very much, Nominee and Honorable Chair.
Yes.
Thank you very much, Mr. Chairman. I would want to congratulate the Honorable Nominee for his elevation and appointment. As he has said already, he's been one of our favorite lecturers at the faculty. So, Mr. Kissi Agyebeng, congratulations. Now, my very first question has to do with investigation and corruption-related matters with respect to the appointing authority. The government of the day is giving you the opportunity to serve in this capacity. The Akufo-Addo administration has been hit with several corruption-related scandals. Oh, please, these are matters of public. So, for example, we've had contract for sale scandal. We've had PDS scandal. We've had cash for sale scandal. We've had the Kelning GVG scandal. We've had issues of visa, Commonwealth visa scandal. We've had issues of Ghana Maritime Authority scandal. We've had issue of the Boss 15 million contaminated fuel scandal. We've had issues with respect to Ameri deal. Now, my question is that how committed are you to investigate corruption and corruption-related matters under this government, particularly when one of the complaints by your predecessor was that government did not give him the needed support to work as an independent special prosecutor?
Honorable Chairman, Honorable Member, I thought you were going to refer to investigation of any of these specific acts you have normally. But you're zooming off them to general questioning. Those ones, are you interested that he investigates any of them? Does it come under his mandate? That's what I would like you to. Yeah.
I'm sure his answers would prompt some of those.
Honorable member, honorable nominee, he listed a number of issues he calls scandals. Do they fall under your mandate? Are you interested in investigating any of these if they are still pending?
Honorable Chair, this is what I would say. I would approach all cases of alleged corrupt and corruption-related issues with the same objective, ruthlessly.
So how do you intend dealing with funding of the and then its associated challenges for the Office of Special Prosecutor? Because I think one of the complaints, again, of your predecessor was that he didn't have sufficient funding. And even though later on we got to know that even the money that was made available was not used by the office. How do you intend dealing with this situation?
Honorable Chair, you know, the first occupant of the seat indeed had no president. He was the first occupant. Before him, there was no one else. So whatever he faced there, I would like to believe were what I'll call teething problems. I would draw from the wisdom of the hindsight of the problems that he faced to chart my own path.
Mr. Chair, as far back as 1970, Justice P.D. Enin reports as follows in paragraph 141 that a deadly virus, he described corruption as a deadly virus that is eating its way into the body politics. If it is not checked and brought under control, it will seriously undermine the effectiveness of the present and the future government of Ghana. And that is as far back as 1970. One of the reasons why the Office of Special Prosecutor was established was to deal with issues of corruption. As we speak today, the corruption perception index is negative when it comes to this administration, and indeed public confidence in the Office of Special Prosecution has really dwindled. What would you do to increase public confidence in the Office of Special Prosecutor?
Honorable Chair, the last corruption perceptions index by Transparency International, we scored 43, which is actually the world average. And the African average, I believe, is around 32. We are not doing so bad. But we need to go beyond. Yes, it appears we've been a bit stagnant on that trajectory.
But that was a reduction compared to 2016. Very well.
Some of the things that I intend to do, I've already stated, Honorable Chair. And I would like to add that I would also I'll be engaging the civil society organizations, the non-governmental organizations, community-based organizations, and investigative journalists. And in this quest, 9th December is International Anti-Corruption Day. Why can't the office stage a conference annually, bringing together experts, corruption watchers, to assess Ghana's progress? And here it is not a talk shop. That is not what I'm interested in, but a platform for peer review. It is one aspect to assess our progress and to encourage ourselves to go further. And then again, the office itself needs some reflection, because if care is not taken and the OSP itself becomes corrupt, then the battle is lost. And so I will institute internal measures to ensure that there is no abuse and integrity of the office is upheld at all times. I would also engage the Chief Justice and the Judicial Service to accommodate the OSP by pushing for the establishment of specialized courts when it gets to the leg of prosecution, specially trained judges, judicial officers, in order to quite effectively bring an end more timeously and in a better nuanced way in respect of the initiation conduct of prosecutions. I have also thought about, and I'm going to give it a push, why can't we institute, for instance, an academic discipline in applied anti-corruption studies with partner institutions? We must start from somewhere, and building on that, in that general scheme of affairs, the body politic itself will feel that, look, we need to do something about our fight against corruption, and the feasibility of the OSP out there engaging in all these activities. And then its legal operations in terms of the initiation and conduct, investigation of criminal proceedings, married together, will go together in assuring what the Honorable Member is asking for. Mind you, I said earlier, Honorable Chair, that we cannot fight corruption solely through the criminal law.
Yes. Thank you, Mr. Chairman. And let me congratulate the nominee once again. Mr. Chairman, a co-conflict, you said? Mr. Chairman, since receiving the nominee CV, I did some work on him, speaking with a lot of his people that I know who know him. And this is a summary of my findings. But one worries me. You are known by your peers to be honest, principled, a fine gentleman, frighteningly knowledgeable, and loyal. The Chairman, my question to the nominee is, if you are considered by your peers to be very loyal, if those people are found in your net, those you are loyal to, how are you going to deal with them?
Now, remember, thank you for the glowing findings you made about me. Now my loyalty is going to be to Act 959.
Mr. Nominee, apart from page 1 of your CV that talks about...
Just a minute there. Your loyalty will be to the act or to the state of Ghana?
Invariably, that is it.
No, I just want clarity. The words are not interchangeable by my understanding of it. For instance, even the Constitution, you would owe and subscribe to it. Loyalty to the Constitution, you've just picked an act of parliament. You are an officer of state, and the concern in Ghana, probably what informed the decision of the president to appoint a special prosecutor, is the inability of political appointees at the level of the Attorney General to deal with the virus and menace of corruption. Now you are narrowing your loyalty to just the Special Prosecutor Act. Is that my understanding? Or to the state of Ghana?
Loyalty to the law, the laws of the Republic of Ghana, the Republic of Ghana.
Thank you, Chairman.
Honorable nominee, apart from page 1, your buy data, page 2, everything talks about law. Page 3, employment history, law. Page 4, law. Page 5, law. Page 6, leadership and positions, law, law, law. Page 7, in fact, even a Kwafu Hall Junior Common Room, legal secretary, law. Conferences, capacity building programs attended, every single one of them, law. Publications, law. Selected papers, law. In fact, honest, notary public, law. We have one football activity passing through. Mr. Chairman, I want to find out from the nominee, do you have any other life? What makes you happy? Reading the law.
Honorable Chair, what makes me happy, I cannot disclose on my CV.
Is that the answer to the question? You have to be a well-rounded person.
Honorable Chair, what I mean to say is I'm very well-rounded. Just that the CV came with guidelines. So I tried to follow the guidelines of the House. But what makes me happy, the guidelines did not capture those things. So I couldn't put them there. But Honorable Chair, at the end, I signify that I like walking. I like to trek mountains. I climb a lot. So at least that's some social life. Being from a mountainous area.
Mr. Chairman, on a lighter note, the nominee said he was from Kwewu. I know him to be from Kwewu. But he made a mistake by saying that his favorite Kwewu food is fufu and nkakra. The Kwewu food is fufu and decolonized apine.
Honorable Chair, I didn't want to cause an uproar by going there. But correction duly noted.
Chairman, thank you, Mr. Chairman.
What did you say? Decolonized apine? What, is that the one they call Air Force?
It's decolonized apine, but fufu and decolonized apine.
I see. That's right. Yes, Honorable Suini.
Thank you very much, Honorable Chair. Honorable nominee, it's on record that I had some reservations with regard to your predecessor, but I had I had no reservation as far as his politics was concerned, because I was very confident that he was not going to be easily swayed by partisanship. So I didn't have a problem with his politics. On the contrary, in your case, many don't seem to know your politics that much. But so many people have expressed reservation about your possible partisanship. And I'm sure it's only time that will indicate if there are reservations, will hold water. I'll start on that note, therefore, to ask if you get invited and do attend meetings of leading New Patriotic Party members to discuss what you may call high-profile, partisan, complex legal cases?
Which are you saying I have been or I am going to be invited?
Do you get invited and do you attend?
No, Honorable Chair.
Okay.
No to both.
Now let me take you back to an earlier question relating to what you refer to as an academic paper that you presented with regard to the 2012-2013 election petition. I have gone through the paper, and I just wish to share 2 quotes with the permission of the chairman. First one, quote, "If the pink sheets were so unreliable, will they form the basis for the declaration of a president?" Unquote. Second one, "I want to tell their lordship," that's quote, "I want to tell their lordship that it is not merely easy to say that by some rebuttable presumption of evidentiary setup that official acts are presumed to have been validly done. Therefore, the figures as provided by the EC are presumed to be correct, especially where in this case the EC itself admitted, though tenuously, that irregularities were recorded in respect of the elections." Unquote. Now, based on these views, and based on the knowledge that, for example, the Electoral Commission in their final declaration declared multiple results before they finally, came with the last one, what is your view on the outcome of the 2021 petition in relation to how the Electoral Commission was presumed to have done the right thing, given these 2 quotations especially?
Honorable Chair, there were dissimilar circumstances, once again. In respect of the first election petition, those quotes emanated from some pronouncements of the judges, some of the judges. Some of the judges went to say that the pin sheets that were brought to court were so unreliable they couldn't do anything with it. That was my understanding of what they were saying. So I was asking a question. That if the pin sheets, which forms the basis for the declaration of a president, that you saw in court, are so unreliable, how then do we have a reliable outcome? Because that is the primary document, if I'm not mistaken. And then the presumption that the official acts are presumed to have been validly performed. This is when the act has actually been performed. Then you come out with that presumption, and anyone who has issues with it will then come trying to rebut it. But in respect of the 2012 election petition, the official act I was referring to had not been performed. And this was it. The refusal or neglect of some of the returning officers to sign on the returns. The act hasn't been performed. There is an absence of a person's signature there. So if you go ahead to say official acts are presumed to have been performed, I was at pains to understand and wrap my mind around as to how that presumption can be raised here when there is no signature. So I actually said that. Did we bother to find out from those returning officers as to why their signatures were missing? In respect of the recent election petition, that's a totally different matter, in that an act had been performed. The allegation was that it wasn't performed well and that there were infractions. Totally different situation from where the act wasn't performed at all. Now, if you come to the conclusion in respect of the recent one, that though there were some mistakes, though there were infractions, but you can still make sense of what occurred. That to me is a different matter from where the act wasn't performed and you are raising a presumption on it to come to a judicial conclusion.
Well, I only litigate it further. I'll move on, just except to say that just like the unreliable pink sheets, it perhaps would have been appropriate if you are minded to comment on it for the Electoral Commission to defend whatever errors happened until, you know, the final one, and not for the judges to presume that what was finally declared was the one to rely on. But I don't want.
Are you referring to the trial strategy?
Yes, partly so. But like I said, it's not. I don't want to litigate it further. I will just move on to my next question so that I'm not, bailed out by the very generous chairman this afternoon. Another question that you were asked by Honorable John Kumar. I would want to do a quick follow-up on that. You have worked closely with Anas Samiria Anas. The president, in opposition whilst campaigning, promised to use a principle he christened the Anas principle to fight against corruption once he was elected. Unfortunately, we haven't seen that. Indeed, some of his leading members have rather been on a war path and have gone to great length to discredit the Anas principle. And in fact, even in the question, it's not one person, even the question of John Kumar, he talked about school of thoughts. And one of the thoughts was to say that that method of gathering evidence is not to be admitted. So it's not one person. So I'm saying that they have gone to greater length to discredit that principle. Knowing your relationship with Anas Samiria and Anas, you have defended that principle in court. Now, your office will require that you gather information, you do investigations. Since the fight against corruption, and can you count, or do you expect the president to fully support you on this?
Honorable Chair, as I quickly, I'm going to use it. Indeed, I also said in an answer to a previous question that I will be engaging investigative journalists in respect of my work if given the nod. I say so because I have intimated that corruption is so secretive and complex, and that unless the participants are coming to you to report themselves to you, it is almost impossible to find it out. Now, if someone can go underground and through a sting operation come out with some evidence which has probative value, it is one of the reasons why I'm sitting here, that I'm going to count on his full support in making this office successful, making it work, making it effective.
Well, your predecessor told us the same thing.
As I keep saying, I won't be wearing his shoes. I'll wear my own shoes.
I'm just putting it on record that he told us the same thing, and now he's saying something different. So I wish you well, though. Finally, you spoke of Article 88, 3 and 4 of the 1992 Constitution. And that got me thinking. Corruption is a high-risk, enterprise. And to fight it, one will need to be very well prepared, because those engaged in it will go at any length to frustrate the fight. Now, you suggested in that answer that the OSP may be unconstitutional, because you talked about the need to clean house because of the especially 88.3. Why did you accept to use this tool that can be challenged by those who may see it as a threat?
Honorable Chair, I was by no means suggesting that it's unconstitutional. I was just admonishing that we need to make things clearer, and not just in respect of the Office of the Special Prosecutor, in respect of the other agencies too. That was my call. I'm never suggesting that it's unconstitutional. I said the concerns I had initially when this process began as a bill and all that, I communicated to the Attorney General then unofficially. And those concerns...
And you said it bordered on the constitutionality of the office. I quoted you.
Yes, the constitutionality when it was mooted, not the constitutionality of the outcome, which is Act 959. They are different things. My concern was that if care is not taken, the Attorney General will be upstaged, judging from Article 88. And so, in order not to upstage the Attorney General, certain provisions ought to be added to flesh it out, to keep Article 88 as it is, whilst adding to it Act 959. And largely, that has been achieved in Act 959. But I was saying, the cleaning of the house, I was referring to that. A bit more work has to be done to make things clearer. As I said in relation to an earlier question, the mother problem is 88.3. If we are able to dovetail it better, it will make things work more effectively and efficiently. So it wasn't a suggestion that 959 is unconstitutional, in my opinion. Not at all.
Okay, can I suspend sitting for 10 minutes? Right.
breastfeeding?
It is safe, easier, and the best, and it helps build the immune system of the baby.
If they're going to feed on their breast milk, what you can do